Hi everyone, welcome back to Immigration Talks with Michelle Mills. I'm Michelle Mills, Managing Attorney for MVMM International Law. Find out more information in the description section and subscribe and like the video. Now, this chat is going to be about the battered spouse petition for residency in the United States. Now, I want to walk through who is eligible and talk a little bit about the filing process for this. Now, if you're with a permanent resident and that person is abusing you, whether you're male or female, then you can apply for this immigration visa petition under the Immigration and Nationality Act as amended by the Violence Against Women Act. The provisions allow certain spouses, children, and parents of U.S. citizens and certain spouses and children of permanent residents, green card holders, to file a petition for themselves without the abuser's knowledge. This allows victims to seek both safety and independence from their abuser who is not notified about the filing. So that's important to note that your abuser will not be notified about the filing. Who is eligible to file? The spouse is eligible to file, and they may also file for their child who is unmarried and under 21 years of age. The parent may also file of a U.S. citizen and you have been abused by your U.S. citizen son or daughter. A child may file if you're an abused child under 21, unmarried, and have been abused by your U.S. citizen or permanent resident parent. Your children may also be included in the petition. So I want to talk about the eligibility of spouses and of children and of parents. So for a spouse to qualify, they have to be married to the U.S. citizen or permanent resident abuser, or the marriage to the abuser was terminated by death or divorce within 2 years prior to filing the petition, or your spouse lost or renounced citizenship or permanent resident status within 2 years prior to filing your petition due to an incident of domestic violence, or you believe that you were legally married to your abuser, but the marriage was not legitimate solely because of the bigamy of your abusive spouse. So if you have suffered battery and extreme cruelty by a U.S. citizen or resident spouse, you are eligible to apply for this visa petition without that abuser being notified of the filing. Now, if you're a child of the abuser, you can also file for this visa petition. You have resided with the abusive parent. There has to be evidence that you are, of course, kin to the abusive resident or citizen. If you're a parent and you're being abused by your son or daughter, you too are also eligible to apply for the visa petition. Now, the filing process, as I talked about, there are specific petitions that you have to file, the I-360, and there are several steps and evidentiary standards that must be met to show, of course, that you are a victim of domestic violence or extreme cruelty by an abuser who is a resident or a United States citizen. So if you need more information about this and assistance, go down, see the description. You can contact me at MVMM International Law. And before you go, subscribe and like. Talk to you next time.